Yes, Mr. Wandroyd. We were still looking at Farmer and Buxted, I think, when we broke.
Indeed. Well, I'd concluded what I wanted to say about those cases in their own right, as it were, and in the course of doing so, I've dealt with my own friend's first to third arguments in support of his case on that part of his case. On the fourth, excuse me, well, it's just a person.
Sorry, just have to remind me, what's the fourth?
We missed. The fourth was that the Upper Tribunal's construction would widen the exemption beyond agricultural buildings, and specifically with reference to paragraph 44 of the decision on page 76.
Right, let me just put away the authorities and I'll get that up.
And I would accept that there is an infelicity in the wording of paragraph 44, in the sense that I think what the Upper Tribunal is referring to in the parenthesis is the ownership of the agricultural land elsewhere. I think what is meant to be said there is used on agricultural land elsewhere, whether owned by Farmer A or by other farmers or both. That is how I had read that. And then a friend calls attention to it, and I think as written, as it were, which seems to suggest that the use may be by other farmers, so that Farmer A has literally nothing to do with this machinery at all, that would be problematic, because it would be hard to see how that shed could be occupied by Farmer A at all, if there's no connection at all between the machinery and Farmer A. But
sorry, I lost you. The machinery in this example.
Yes.
Well, actually, the example doesn't say that Farmer A owns the machine, but I assume that he does.
Well, that is certainly the sense of the example that I think is trying to be given here. Is that
so? The example, I think, is we are to interpret this as meaning Farmer A owns the machine.
Yes.
He owns and occupies the shed in which the machine is kept. And the machine is used, the shed is adjacent to agricultural land, also occupied by Farmer A.
Yeah.
But the machinery is used on agricultural land elsewhere. Now, whether by Farmer A or other farmers, well, bearing in mind that Mr. Rainsford was talking about operating machinery on a contract basis.
Yes.
That could be on land which is not in any way, has nothing to do with Farmer A, couldn't it?
Indeed.
So you say you want to say, interpolate whether owned by Farmer A or anybody else.
Yes. In terms of the land.
It doesn't matter on the Rainsford interpretation, because Farmer A can just be a contract.
Indeed. But one reading of that paragraph, and I think the reading my own friend was taking, was that Farmer A isn't even a contractor, and the machinery is the use of the machinery is by some other.
Well, I think that's implicit in the parenthesis, whether by Farmer A or other farmers. Well, so they're not saying that Farmer A's got to use it; they could be other farmers.
Yeah. Well, if that is what they were saying, then it may be that that's going too far, because if that's the basis of it, it's hard to see how the shed would be occupied by Farmer A at all.
I don't understand that. If Farmer A owns the shed, occupies the shed and owns the machine, why isn't the shed occupied by Farmer A? Even if the machine is then subsequently leased out to other farmers who's got nothing to do with farmer A.
No, I take the Lordship's point. The problem is maybe not so much with the occupation as such, but it is it is that is a situation in which there is really because it's not the same enterprise, it becomes a separate enterprise then, and the so sorry, I've let this down false stop there. Because the way the Upper Tribunal construe the words is that it has to be a part of the same enterprise, and if it were if it were simply, as my friend says, a sort of a higher business where Farmer A has no involvement with operating the machinery at all, then that would take it outside the realms of contract farming and into the realms really of a separate enterprise. So that is the to that extent, I think.
The Upper Tribunal doesn't say anything about a same enterprise, is it? In that section?
That's the test. It is.
That's the test. It applies in full paragraph 48.
Yes. And that's why I think in 44 they must have been talking about land owned by Farmer A or by other farmers, rather than, as it were, the use being done by someone else. But
and Mr. Ormsrod, I'm a little bit confused. Are you saying that in 44 the machinery is owned by Farmer A or not?
yes, it is owned by Farmer A and used by Farmer A. But the point is, it doesn't matter whether he uses it on his land, other land, or both. That's the crucial point, and that is the point driving the Upper Tribunal's driving the Upper Tribunal's interpretation. My own friend says that interpretation goes too far because it would allow Farmer A to simply operate a sort of higher shop off his farm, and without any involvement by him in the farming being done with the machinery, and he prays in paragraph 44. And my submission in response is to say that I think that may be a mistaken interpretation of paragraph 44. If it is, if that is what the tribunal was meaning to say in that paragraph, it did go too far and further than it in fact goes in formulating the test, and so it could be corrected without affecting the essential logic of the interpretation.
So I think really what you're saying, if I've understood correctly, is that paragraph 44 is not entirely clear.
Indeed.
On one reading it goes too far.
Yes.
But on the other hand, it's not consistent with the single enterprise test which the Upper Tribunal applied in paragraph 48.
Yes. And
in order to reconcile 44 and 48, give them some sort of consistency, you need to read down paragraph 44 so as to tie it in with paragraph 48.
And had I been more diligent, I would have pointed that out to the Tribunal in the process of correcting the decision. But the point has only struck me today in the course of friends' oral submissions. So, but either way, it doesn't affect the logic. It doesn't affect the logic on which I rely on the Tribunal relies. Now, my learned friend's argument under this point takes a broader nature as well, and he gave various other examples of buildings which he said or implied were obviously not agricultural buildings, but will nonetheless be caught by the Tribunal's test. Well, I mean, my main submission on that is that those cases would have to be considered on their own facts in the light of what the law says, and one can't prejudge them by labelling certain buildings as though they definitely ought to or definitely ought not to qualify for exemption. More specifically, I revert to the point that I made with reference to Eastwood, that there is no requirement for an agricultural use of the building per se. And the very example my own friend gives in his skeleton of a poultry processing factory, which he says in his skeleton is an obvious example of something that cannot come within the occupied together with requirement because it lacks an agricultural function. That example is actually one which tells against him, because as we saw in Farmer, the Lands Tribunal and the Court of Appeal were perfectly happy with poultry processing factory coming within the use test. And we also have in the Bunyan, we don't need to go through the case of Prior and Sovereign Chicken, which is again a case in which poultry processing factories are found exempt. So there is no getting around the wording of the statute and simply asking, oh, does this look like an agricultural building? That's not a good argument against the Upper Tribunal's construction. My own friend's fifth point was in respect of the difference which would arise on the tribunal between paragraph 3 and paragraph 5. I accept that is that would be an unfortunate consequence of it, although in my submission that simply goes back to the fact that Schedule 5 is something of a patchwork of different exempting provisions, and Parliament has amended one, not amended another. So that is why we get potentially to that result. On the broader question of consistency with the other provisions of Schedule 5, I've addressed that at paragraph 62 to 64 in my skeleton. In the broader terms in which my other friend made that argument in the skeleton, he hasn't pursued those broader points about inconsistency with Schedule 5 in his oral submission. So I don't propose, unless I can insist your lordship on it, to add to what I've said in writing. So much for the 5 points. My own friend also then, in the alternative, as it were, challenges the Upper Tribunal's application of Farmer and Buxted to the facts of the case.
Mr. Ormond-Royd, we don't need to hear you on that.
Thank you. Let me come then to my further argument in support of the Upper Tribunal's decision.
This is your respondent's notice point.
It is. And this is not an argument which features in the Upper Tribunal's decision. That is entirely my fault, not the fault of the Upper Tribunal, because although I relied in general terms on the fact that the buildings in the same hereditament as other agricultural land, I didn't. That was, as it were, one factor among many, and in passing, and I did not advance the same focused argument as to the law that I've developed before this court. Now, this argument is essentially an argument about what the ratio of farmer means, and it seeks to give some further content to the concept of an agricultural unit, and it's consistent with a finding that the ratio of farmer applies to paragraph 3.1 in its post 2003 incarnation. And as I note at paragraph 74 of the skeleton, it's not, the concept of an agricultural unit is not a statutory concept. It's not one that featured in the case law before Farmer, and it's not one that needed much definition in Farmer itself, because the facts of Farmer itself were so extreme that they obviously didn't fit within the concept of a single agricultural unit, however that was defined or understood. So, but the result of that is that one is left with something of a lacuna as in terms of what that means and how it's to be applied in cases unlike Farmer, which have facts nearer to the dividing line. And my submission is that there are a number of features of the statutory scheme which suggest that if looking at it as a whole, which support the approach of saying that where a hereditament contains agricultural land, the buildings within that hereditament are occupied together with the land. And I have three features in mind. Firstly, is the link between the hereditament and the concept of occupation. And classically, a hereditament may be said to be defined by occupation in the sense that one cannot have two rateable occupiers of a hereditament unless they are joint occupiers of the whole. And authority, if needed for that, is in the Atos case, which I cite in my skeleton, but it doesn't come into the authorities bundle as the proposition is not controversial between me and a friend. So, in other words, something which would otherwise be one hereditament can be split up into multiple hereditaments by a separate occupation. So, if you have separate rateable occupiers of 2 floors of a house, that becomes 2 hereditaments. Separate rateable occupiers of 2 halves of a field, that becomes two hereditaments. So there is a link between definition of the hereditament and identification of the rateable occupier. And the concept we're dealing with, obviously, and occupied together with, is again starts from occupation. So that's the first link. The second link is between the concept of a hereditament and the concept of an agricultural unit. And I already referred in my submissions on Farmer to the way that the House of Lords, as my friend says, placed particular emphasis on the Midlothian assessor decision as a basis for deriving the concept of the agricultural unit. And the Midlothian assessor case was a decision about the extent of the hereditament. And if we just see, don't go behind that in the sense that common ground that the House of Lords did find it important in defining the concepts of an agricultural unit. But I just take the Lordship to it briefly, just to show how the concepts relate in Scottish law. And it's at tab 11 in the authorities bundle. It's a decision of the Land Valuation Appeal Court, which, as I understand it, is essentially of equivalent seniority to the Court of Appeal in the Scottish legal system. And we see on the first page, page 131, that it concerned a claim to agricultural exemption under the relevant Scottish legislation at the time for woodlands, which comprise themselves several scattered areas of land, and then also, and the claim for exemption was in respect of sawmills, mostly on entirely separate sites again. And we see that Lord Sawn dissented. Lord Patrick's judgment in the majority starts on page 134. And the first sideline passage sets out the facts of the first case. It's about a sawmill serving a dispersed group of woodlands. And over the page between 134 and 135, we have the Scottish legislation at the time.
The definition of agricultural buildings is pretty close to the English one.
It is quite close, yes. It has the occupied together with requirement, it has the used in connection requirement. But what it also has is this, sort of strangely by implication, it has this requirement that the buildings have to be on hereditament, on hereditament comprising agricultural land. And they read that in from this word thereon. Just at the top of page 155, does not include any buildings thereon other than agricultural buildings. So from that exclusion, they reason that it can only apply to buildings thereon, and buildings thereon means a building on the hereditament, hence why they get into what is the hereditament. In that context, we see halfway down page 135, well, just above the sideline passage, that gives you the reasoning for why thereon means it can't apply to buildings which are not on agricultural land. Secondly, there are excluded buildings which, although situated on agricultural lands and heritages, are not occupied together with them. It's not easy to find a content for this exclusion. If, for example, there were buildings on a farm which were not occupied by the farmer, they would be considered as a separate entity and would be excluded from or entered in the merits. So what he's saying is, well, in a context where the exemption only applies for buildings which are on an hereditament comprising agricultural land, it's not easy to find any content, and indeed they don't find any content, for the occupied together with requirement, because if it's on the same hereditament, it's obviously already occupied together with the rest of it. And that is a difficulty, I suppose, caused by an imperfect blending of the Scots and English law. We can go on and see that the exemption failed in this case because the buildings were indeed held not to be thereon, so they didn't form part of the relevant hereditament. But I don't need to take through that. But what I've shown already shows why the discussion of the provisions in Scottish law naturally focused on the concept of the hereditament, and it effectively aligns the occupied together with requirement with that. And the focus in that context is on geographical contiguity rather than function. And we've seen how this case. So if I just go to Farmer, actually, to the argument in Farmer, which my friend also referred to, it's page 194 to 195 in the authority bundle. And that's the submission for the rating authority. All the relevant tests in deciding whether in fact the buildings under consideration are a poultry farm. The ultimate test must be whether a building or group of buildings is part of the farm or poultry farm, or rather the unit, quote unquote, and that is the context in which the Midlothian assessor case is cited. And that seems to be picked up by Lord Slynn, as he also refers to the Midlothian assessor case and its preference for geographical closeness over a mere functional relationship, and uses that as the springboard for his discussion of the agricultural unit. So it's evident that he had the concept of the definition of the hereditament, or the unit of assessment, in mind when he was deriving the concept of the agricultural unit. But we do note that his concept of an agricultural unit is a little looser than that of the Scottish court in the Lothian Assessor, because he does, as your worship will recall, allow for the idea that land in adjoining villages and so on may be one agricultural unit. It seems to spring from the same root as the unit of assessment, but allow for a looser application in some cases. One can see the connection from the other end of the telescope, as it were, between hereditament and agricultural unit. If we look, if your worship will excuse me, taking you briefly to Woolway, just to highlight what the principles on hereditaments are. And this is tab 16 of the Authorities Bundle, page starts on page 202, and the facts are well known. It's related to whether separate floors in an office block, which were in separate occupation, could nevertheless be treated as one hereditament. And just to note there that the whole point was that they were in the same occupation. Had they been in separate occupation, there would have been no question of them being the same hereditament. Page 206, Lord Sumption gives the judgment of the majority. Page 208 at paragraph 6, the sideline passage, he is grappling with the geographical and functional principles, just as in the cases on Occupy Together with. So, so there are similar concepts at play, and particularly relies on the Scottish case law. And at C, he says these cases establish that the primary test is geographical, but that a functional test may in certain cases be relevant either to break up a geographical unit or to unite geographically dispersed units. And gives an example just after that of a factory within the curtilage of a house. That would not form part of the same unit of assessment because it's used for an entirely separate function. It's of note, if we go on to 211, that one of the cases he has in mind and cites in.
Sorry, can I just ask you about paragraph 6? He says the primary test is geographical, but a functional test may in certain cases be relevant either to break up a geographical unit into several subjects for rating purpose, or to unite geographically dispersed units in unum quid. Is he talking there about breaking up a hereditament into several hereditaments for rating purposes and uniting several geographically dispersed hereditaments in unum quid?
Yes. Yes, that's what he's talking about. In the context of defining a hereditament, you look first at the geography and then, you look first at occupation in the sense that the area has to be in the same occupation to get to even qualify. And
when he says several subjects for rating purposes, he doesn't mean necessarily several hereditaments, because here, if I've understood correctly, Chequer Tree Farm is agreed to be a single hereditament, but parts of it are not entitled to the agricultural buildings exemption. So there's no breaking up of the hereditament, it's just that part of it doesn't qualify for exemption. Is that right?
Oh, indeed, and I don't dispute the proposition that within a hereditament, certain parts may be exempt, other parts may not be exempt. It says as much in the schedule. It says it's exempt to the extent that it consists of agricultural land buildings. the point is a more focused one as to the application of the occupied together with requirement within that.
Yes, but I mean, it does mean that your focus on the extent of the hereditament may not reflect the true application of the exemption, where only part of the hereditament qualifies for the exemption.
Well, I'm focusing on the hereditament to try and illuminate the concept of the agricultural unit as an expression of the occupied together with test. So, I don't think I can express it more clearly than that. But I accept that, that there will be cases where, and indeed this is one, where parts of the hereditament will be exempt and parts not, because they have to meet the test for exemption, you have to meet all parts of the test, and so it's quite possible that there will be buildings which are occupied together with agricultural land but used for purposes that take them outside the terms of the use requirement, for example. That's quite possible, and that appears to be what is the case here with those other buildings which are not exempt. But I just before leaving Woolway, just a note on page 211 that it is sorry, 210 going over on 211. He refers in deriving the approach to hereditament to the Midlothian assessor case, and indeed to the citation of that with approval by Lord Slynn of Hadley in Farmer and Poultry. So, recognition that both cases are dealing in similar principles. Paragraph 12 over the page is the well-known passage which, as it were, reconciles the geographical and functional tests when it comes to defining the hereditament. This case stands as a testament to the importance of a clear framework as to how one reconciles those principles in hereditament cases. It would be of assistance to those who have to operate the provisions on agricultural exemption if there was some similar framework or some similar guidance as to how the geographical and functional principles apply in the context of the occupied together with requirements. And given that the two concepts have grown up from the same root, in my submission there will be logic and good sense in recognising that there is a degree of overlap between them, in the sense that where land and buildings form one hereditament, they are occupied together with one another. So that's my second point, the link between the hereditament and the concept of the agricultural unit. Thirdly, if one looks to the overall statutory scheme, this reading of the occupied together with requirement as construed in Farmer would make paragraph 3.1 fit more neatly into the overall statutory scheme. Firstly, because the ratio of Farmer could then be more easily reconciled with the amended use requirements. If the occupied together with test is satisfied by geographical contiguity and the absence of use for a wholly different purpose, then it wouldn't run counter to the amended use requirement in the way that Muller and Friends construction makes it do. And therefore, one could preserve the same meaning for the occupied together with requirements across the different paragraphs of Schedule 5. So that is the primary attraction of this construction as opposed to the Upper Tribunal's construction. Second, and more broadly, it would make the approach to paragraph 3.1 buildings more consistent with the approach to other buildings in Schedule 5, where in general there is a far lower hurdle than the appellant is seeking to impose in this case. So, for example, livestock buildings. Livestock buildings need only be contiguous to a small area of agricultural land to be exempt. That land doesn't have to be in the same occupation or even in the same ownership. It just has to be next door to the livestock building. Another example is buildings occupied by multiple occupiers or by corporate bodies. They do not require any occupational link to land, agricultural land at all. Schedule 5, paragraph 7. So if one takes the example of a poultry processing plant remote from any agricultural land but occupied by two farmers whose livestock buildings qualify in paragraph 5, that factory would be exempt despite the lack of any geographical connection at all to agricultural land, agricultural unit or the hodissement of any sort. And that arises from the term of Schedule 5, paragraph 7.2 and 7.4. So in that broader context of Schedule 5, an onerous construction of paragraph 3.1, which seeks to say, well, okay, your buildings are in the same hereditament as agricultural land, but that is not enough. You need to show more connection. That runs against the grain of certainly of Schedule 5 as it now stands, and so in my submission, that's an indication. That's an indication in support of my construction. I've cited the case of Harding in tab 21 in the bundle, not because I say it persists, but just out of abundance of caution. It was dealing with the concept of an agricultural unit in the planning legislation. I don't say that has any real relevance to, or any relevance at all to what you are determining in my argument. My learned friend hasn't gone to it in his submission, so I don't want to take the issue to it. So I offer that further argument as an alternative basis to support the decision of the Upper Tribunal, and one which perhaps would be of assistance to practitioners and would give greater clarity as to what was meant in farmer agriculture and how does one show that that requirement is satisfied. That leaves me only to address the third point about use.
I don't think we need to hear you on that either, Mr.
In that case, unless I can assist you any further, I've also finished a little.
Yeah, thank you very much. Mr. Williams, do you wish to reply?
Well, I'm so sorry. Before I sit down, there was one single point which I should have said, but just to correct something my friend said, that he said that the eggs are sent, I think he said words to the effect, sent directly to the supermarket shelves. I don't think there was any evidence about this, but my instructions are they're not sent, as it were, to individual supermarkets. They are sent to a distribution centre owned by the supermarket, which then distributes them. So just to correct any unintentional impression it might have given that.
Yes, Mr. Williams.
Great. Well, if I may obviously just reply on the occupied together with.
Yes.
My learned friend submits that the treatment of the test, the occupation test in Herod and Farmer is an interpretation by the court of the composite section, both the occupation element and the use element. And I submit that that's not correct. It's obviously a contextual analysis, as one would expect, but in interpreting the phrase occupied together with, the court does not rely upon or derive anything from the use element. I didn't take you back to those passages just to make that submission. The phrases are interpreted and applied as distinct cumulative tests. My Lords, that's also relevant in my submission to the presumed intention of Parliament in retaining that phrase at a time that the use element was amended, the phrase that was the subject of the judicial consideration in Farmer was not. Second point, my Lord, my learned friend said that because my submission is that the use element is neutral in that it may be on that land or other land or both, that means that my interpretation allows for use, an exclusive use of other land, and that I would say in those circumstances the occupation test would not be met. And my Lord Mayor, the answer to that is, well, it probably wouldn't, but that would be the subject of separate assessment against the occupation test in the circumstances of the case. Then you get into the difficulty of the paragraph 44 example as to what assumptions being made as to occupation. That's entirely unnecessary. The use test is saying no more than, yes, the building can house equipment that's used on your land, other farmers' land, or both. But if that is the case, one still has to focus on the occupation test because it has a different role, and that requires a separate evaluation. I mean, for what it's worth, I think the example of paragraph 44 is really intended just to highlight that in that example there's no functional connection between the land and the building.
That's the example in 44.
44. Thank you, my Lord. My Lord, submissions were made as to what my learned friend described as the unfortunate consequence that the meaning is then different between paragraphs 3 and 5. And in my submission, again, this is relevant to Parliament's intent. If it had intended there to be this unfortunate consequence, then it would have achieved that by amending the occupation element. And also, referring back to my submissions on the legislation at the outset of my submission, the court will recall that paragraph 5 deals with primary livestock buildings subject to a different test from ancillary livestock buildings, whereas paragraph 3 is all about ancillary buildings, and it's in that like context that the phrase occupied together with is made. And then my final point to address is the respondent's notice point. And fundamentally, my submission is that as developed, this is not an interpretation of Farmer and Buxted. It's providing a different test. The Farmer test is by reference to those various factors that Lord Slynn referenced: common occupation, joint management, joint control at the same time, due to the function and physical nearness, whether the land and buildings is worked as a single agricultural unit. And my Lord Mayor, that is not the same as saying, is it a hereditament that includes agricultural land? You have my submissions from earlier. There may be a degree of overlap, but the exemption test is an overlay, so that even where a building is in the same hereditament, even where that hereditament includes agricultural land, the building still needs to meet the specific exemption test, which requires it to be occupied together with the agricultural land in that hereditament. A learned friend asks, or queries whether the respondent's notice test would be more workable. Well, this test, the Lord Slynn test, has been applied since 1992, and there's been no suggestion that it's unworkable. It wasn't amended in 2003. And in my submission, it's not correct to describe it as particularly onerous. It's simply the test for ancillary buildings that has been put in place by Parliament to be carried along with the exemption that applies to agricultural land. So, my Lord, those are the points I wanted to make.
Thank you very much. Well, thank you both very much for your interesting and economical submissions. Although you will have some idea of the way this appeal is going, all I will say for now is that we will reserve our judgments. You will get a written draft in the usual course of events. It comes with a fierce embargo, which means what it says, and so it can only be distributed to those on the distribution list. It'll be your opportunity to correct any grammatical and other minor errors. There's not an opportunity to raise new points or to disagree with our reasoning, and we would hope in the light of the judgments you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions, and we will make the form of order that we consider to be appropriate. The judgment in its final form will be handed down remotely, electronically, by release to the National Archives and to the parties, so there will be no need for any further attendance. Thank you all very much.